So in this video, we're going to talk about a different kind of case. This is what's called a product liability case. And the one I'm going to talk about today is called a defective motor vehicle. Very common kind of case in terms of defect claims. We've handled several of these. We enjoy these cases. They're interesting cases, and they're always very compelling, and we find them very worthwhile. As you've probably seen in the news, recalls are pretty much at an all-time high. In spite of all the advancements in technology, we see more and more recalls as these cars go from simple mechanics to computers. But there are some things you need to know about these cases that are really, really important. Really important. No attorney can help you unless you know this up front. And this is very important. It's not intuitive. So please listen to this if you're watching this video and you think you may have a defective car claim, a defective motor vehicle claim. First of all, you have 1 year to file that claim. That is not a lot of time. That is the shortest statute of limitation on the books, 1 year. And it takes an attorney months to work up these cases. So you don't want to wait until the 11th month to talk to the attorney. Number two, this is the most important advice I can give you. You have to keep the car. You have to keep it. In product liability cases, there is no proof without the product. If you have no product, you have no case. So this is your evidence. In murder cases, it's guns and ballistics. In product liability cases, it's the product. And if you get rid of the product, as we usually do when a car has been totaled or significantly crashed, you have no case. I dealt with a gentleman one time. He called me on probably the 10th month of the statute of limitations. Had one of the most significant product liability cases I'd ever seen. But guess what? He got rid of the vehicle. It was destroyed. He let them shred it. I called the towing company. I called the car lot. I called the junkyard, and finally had to confirm that it had in fact been shredded. And his daughter was killed in this, along with 2 other people. And I had to tell him that had he just kept the vehicle, we could have done some justice in that case. And that was a very, very sad conversation to have with that dad. So this dad assumed that and this is what he told me, it's very logical. He said, Ryan, there was a recall on that vehicle, and we don't need the vehicle. We can just tell the jury that there's a recall on it, and that proves their case. That sounds great. That makes a lot of sense. But unfortunately, that is not the law. Believe it or not, there is a specific rule of evidence which says if there has been a recall on a vehicle, you cannot introduce evidence that there was a recall to prove that it was defective. So here's what you need to know about recalls. Recalls happen, and recalls very often are an admission that a company has screwed up, that they've got a product out there that's killing people. That's why they're doing the recall. But there is a specific rule of evidence, and I can show it to you. And it says that if there has been a recall, you cannot introduce proof of the recall in a courtroom to a jury to prove that this product was dangerous. That is really significant. So that means that we have to prove that the case was defective from scratch. We can't rely on whatever the federal government's done. We can't rely on the statements that the car company has made in public about the defect and the recalls. You have to go solely from whatever your engineer, whatever your expert finds within that vehicle to say that it's defective. So again, you cannot introduce evidence of the recall. This dad was very surprised when I told him that. That didn't make any sense to him. If you want to know the reasoning behind that, it's very simple. If we started punishing companies for recalling things, they would never recall them. That would be the net effect, is you would be hammering companies with jury verdicts simply because they recalled a vehicle. So the burden is on us, the burden is on me and you to hire experts to go and look in the vehicle, get inside the vehicle, often with microscopic cameras and computers, to figure out what was it in this vehicle that went wrong to cause this problem. So that is crucial. You have to keep the vehicle. The other thing I would tell you is not only keep the vehicle, don't settle your property damage. Take the vehicle, put it in some form of dry storage, put it in a tarp, do something to preserve it. That is a very valuable piece of evidence. You also need to consult with a lawyer very quickly because, again, the conditions in the car, they may degrade, they may erode, and you may lose evidence. And finally, the last thing you need to know about these cases, they're very similar to medical malpractice cases in this sense, but these are extremely expensive cases to put together. Usually requires multiple, very expensive experts to prove these cases. Meaning, if you call my office and your airbag didn't deploy and it broke your nose, guess what? We're not going to take that case, because the cost of proving your case is far, far greater, I assure you, than the cost of a broken nose. I'm sorry about your broken nose. You have a product liability claim in theory, but the economics of it, unfortunately, don't add up. In product liability cases, we usually have to have, unfortunately, a very severe, permanent, catastrophic injury or death to justify the expenses associated with these cases. And you can talk to many attorneys and they'll tell you the same thing. Medical malpractice, those cases are even more expensive and far harder for that matter. And again, very, very minor damage to the body or a very temporary injury. These are not the kind of things that you want to take into a multi-year litigation against Nissan or Ford or Toyota or whoever. So you need to understand these are very hard, very serious cases. They're not anything like your typical car wreck. They're against large multinational companies, and they're very expensive. And absent a really, really serious injury or death, you're going to find that most attorneys aren't going to take these cases because it doesn't make any sense for you or for me.